Imagine you're a business, right? Or even just an individual navigating the exciting world of cross-border commerce. Everything's going great until suddenly, boom, a major disagreement flares up.
Yeah, that happens.
And taking that dispute to court in a foreign country, it can quickly become, well, slow,
Right.
incredibly expensive, and frankly, pretty unpredictable. You're trying to figure out unfamiliar legal systems, maybe different languages. It's a mess.
A real headache.
So what's the alternative when you're caught in that kind of bind?
Well, that's where international arbitration comes into play.
Exactly. It offers a structured, often, more efficient, and hopefully far more predictable path to resolution. Today, we're taking a deep dive into a really crucial piece of South African legislation that underpins this whole process, the International Arbitration Act 15 of 2017.
That's right. Our mission today is to unpack this act in a clear and engaging way. We want to make it accessible whether you're, say, a seasoned legal professional, a law student, or maybe just a curious business owner. We'll look at its purpose, its key features, the legal context, its practical side, and, why it actually matters in the real world. Think of this as your guide to understanding why this act is such a cornerstone for global trade, and we're working directly from the Consolidated Act itself, plus its schedules.
Great. Okay, let's get into it then. Why did South Africa need a brand new International Arbitration Act back in 2017? What specific problems was it trying to solve? Why was this so critical?
Good questions. Well, this act, which actually became law very quickly in the late 2017, it serves several really vital purposes, all designed really to boost South Africa's position in the global economy.
Okay.
First, it just makes it easier and more appealing for businesses to choose arbitration for resolving international commercial disputes here. It's about making the process smoother, more user-friendly.
Streamlining it.
Exactly. Second, and this is a really big deal, it directly brings the globally recognized UNCITRAL Model Law on International Commercial Arbitration right into South African law.
Okay, UNCITRAL Model Law will need to unpack that.
We will, but think of it like an international blueprint for arbitration laws. By adopting it, South Africa basically signals to the world, hey, we're playing by the same modern rules as everyone else.
Right, standardization. Makes sense.
It makes South African law much more predictable and trustworthy for foreign businesses. Then third, it creates clear ways to make sure international arbitration agreements are respected, and crucially, that foreign arbitration decisions, they're called awards, are actually recognized and enforced here.
So the decisions have teeth.
Precisely. And finally, it brings South Africa fully in line with its obligations under a major global treaty called the New York Convention. That convention is like the bedrock of international arbitration worldwide.
So if I'm getting this right, it's really about making South Africa a more predictable and trustworthy hub for sorting out international business disputes. It's like sending out a big sign, come do business here. If things go sideways, we have a clear, internationally accepted way to fix it. Is that the core idea?
That's exactly it. It replaced an older, frankly outdated 1977 act and tweaked some other related laws. It wasn't just a minor update, it was a significant overhaul.
Right.
And what's also quite telling, I think, is that the act explicitly says it binds public bodies too, government departments, municipalities, you name it.
Oh, interesting. Even the state.
Even the state. This sends a really powerful message to international investors. South Africa is serious about applying these fair global standards, even when the government itself is involved. It shows a deep commitment to legal certainty.
That is a powerful statement. Okay, you mentioned this model law, the UNCITRAL one that the Act brings in. What exactly is that, and why is it so fundamental here? And how does it define what counts as an international commercial arbitration anyway?
Okay, so the UNCITRAL Model Law, it's laid out in Schedule 1 of the Act. It essentially is the law in South Africa for these matters, subject to the Act itself, of course. Like I said, it's that universal blueprint. It was created by the UN specifically to promote consistency across borders. So when judges or arbitrators here interpret it, they're actually guided to consider its international roots and the need for global uniformity.
So a ruling here should ideally line up with one in, say, London or Tokyo.
That's the goal: consistency, predictability. The Act also clarifies key terms, which helps. For example, an arbitration agreement has to be in writing, but crucially, that now explicitly includes things like emails and electronic records, reflecting how business actually works today.
Makes sense. Modernizing.
And it defines conciliation clearly to include mediation, just broadening the options for parties to settle things amicably if they want to.
Okay, so definitionally, what makes an arbitration specifically international under this act?
Yeah.
How do you draw the line between that and just a regular domestic dispute?
Yeah, that's a really crucial distinction. The model law sets out clear tests. First, if the businesses involved have their main bases in different countries when they sign the arbitration agreement, it's international. Simple as that. Second, even if they're based in the same country, it can still be international if the agreed legal location for the seat, or the place where a big chunk of the business deal happens, or even just the place most closely connected to the dispute itself, is outside their home country.
Right, so location matters.
Well, location
Yeah.
matters. And third, it's international if the parties just flat out agree in their contract that the subject matter involves more than one country.
You could just declare it international.
If the subject matter genuinely relates to more than one country, yes, their agreement confirms it. And this distinction is vital because, generally speaking, South Africa's older Domestic Arbitration Act from 1965, it doesn't apply to these international cases covered by the 2017 Act.
Okay, so separate tracks.
Exactly.
Yeah.
A dedicated, specialized legal path for cross-border stuff, keeping it distinct from purely local disputes.
And what about the courts, the regular South African courts? What's their role in this international arbitration picture? Do they just, like, step back completely, or do they get involved sometimes? They're referees?
That's a fundamental point. The model law sets out a core principle, Article 5, which basically says, in matters governed by this law, no court shall intervene except where so provided in this law.
Okay, hands off mostly.
Very much hands off. The intention is minimal judicial interference. Courts are meant to support the process, not run it. They act more like essential support staff or a safety net in specific defined situations.
Like when?
For instance, a court might step in to help appoint an arbitrator if the parties are deadlocked, or maybe to rule on a challenge to an arbitrator's impartiality. But, and this is key, they generally won't reopen the actual substance of the dispute. They respect the tribunal's role.
Got it. So efficiency and respecting the party's choice to arbitrate.
Exactly.
So, okay, let's walk through it. If a business or maybe a law student listening is looking at this act, how does an international commercial arbitration actually play out? What are the key stages, the main features someone would encounter?
Right. Well, the Act basically says you can arbitrate almost any international commercial dispute, provided the parties agree to it. The main exceptions are if South African law says that specific type of dispute can't be arbitrated, some family matters perhaps, or if the agreement itself is against public policy.
Yeah.
And an important point, just because a court could theoretically hear the case doesn't stop it from going to arbitration. Arbitration is a valid choice.
Okay.
Now, a massive drawcard of this system is what's called party autonomy.
Party autonomy. Heard that before. What does it mean in practice?
It means the parties themselves have huge freedom to design their own arbitration process. They can agree on how many arbitrators they want. If they don't agree, the default is just one. They choose how those arbitrators are appointed. They decide the language or languages to be used. They can even agree on the specific rules of procedure they want to follow. And, crucially, they choose the juridical seat, the legal home of the arbitration.
Wow, that's a lot of control.
It is, and that flexibility is incredibly attractive for international businesses. They can tailor the process to fit their specific needs, the nature of the dispute, even their cultural background sometimes.
Okay, that makes sense. What about protecting the people actually running the show, the arbitrators? I imagine in high-stakes international disputes, there could be pressure, maybe even threats. Is there anything in the Act for them?
Yes, absolutely. The Act tackles this head-on in Section 9. It gives arbitrators, and also the institutions that administer arbitrations, immunity from being sued for things they do or don't do while carrying out their functions.
Immunity, like diplomats.
Well, sort of, but specifically for their arbitral duties. The only exception is if they act in bad faith, intentionally doing something wrong.
Exactly.
This immunity is vital. It lets arbitrators make difficult, impartial decisions without constantly looking over their shoulder, worrying about frivolous lawsuits. It protects their independence and the integrity of the whole system.
That's crucial.
And the Act also lays out clear steps if you do need to challenge an arbitrator, say, for bias. There have to be justifiable doubts, meaning solid, reasonable grounds to think they might not be impartial.
Okay. Now, you mentioned earlier that public bodies, like government departments, are bound by this act. What does that mean for confidentiality?
Arbitration is usually private, right? But government stuff is often public. How does that work?
That's a perfect example of the balancing act this legislation performs. You're right, arbitration is generally confidential, But Section 11 introduces a specific rule for public bodies.
Okay.
If a public body is a party to the arbitration, the proceedings are actually held in public by default.
Oh, interesting. Open doors.
Yes, unless the arbitral tribunal specifically directs otherwise, and only for compelling reasons. This upholds the principle of public accountability when government entities are involved.
But what if it is kept private? If the tribunal decides it should be private, or if it's a purely private dispute without a public body, then yes, the award and all the documents are confidential. The main exceptions are if disclosure is required by law, or if a party needs to reveal something, like the award itself, to enforce their legal rights.
So it tries to balance transparency with the traditional privacy benefits of arbitration.
Precisely. And beyond that, the model law embedded in the Act ensures basic fairness throughout the process, things like equal treatment for all parties, everyone getting a proper chance to present their case. It covers the whole flow, from submitting claims and defenses to how hearings run, even what happens if one side just doesn't show up or participate.
Right. And what if something urgent needs to happen quickly? Like you need to stop someone from selling off assets that are part of the dispute or prevent ongoing damage before you get the final decision. Is there a way to get quick, temporary orders?
Yes, definitely. The model law has a whole section, Chapter 5A, dedicated to what are called interim measures.
Interim measures.
An arbitral tribunal has the power, unless the parties have specifically agreed otherwise, to order temporary actions. These could be things like maintaining the status quo, stopping potential harm, preserving assets needed to satisfy a potential award, or safeguarding crucial evidence.
How easy is it to get one of those?
Well, the party asking for it usually needs to convince the tribunal of two main things. First, that they're likely to suffer harm that can't easily be repaired later by money if the measure isn't granted. And second, that they have a reasonable shot at actually winning the main case.
Makes sense. You need a good reason.
Exactly. And courts also have a limited backup role here. They can grant interim measures too, but typically only if the arbitral tribunal hasn't been formed yet or isn't able to act quickly enough or maybe lacks the power to grant the specific type of order needed.
So the tribunal is the first port of call.
Generally, yes. And interestingly, court decisions on these interim measures usually can't be appealed. Again, it's about speed and efficiency for these temporary steps.
And then the final decision, the award.
The final award has to be in writing, signed by the arbitrator, clearly state the reasons behind the decision, and include the date and the juridical seat, that legal home we talked about. The tribunal can also decide on interest and who pays the cost of the arbitration.
Okay, that covers the process. Now, the really practical bit, what does all this mean for making sure an arbitration award actually, counts, that it can be enforced? And conversely, how easy is it to challenge an award if you think it's wrong? This is the bottom line, isn't it?
Absolutely. This is where the rubber meets the road, and it's a core strength of the Act. Chapter 3 of the Act, working together with the model law and the New York Convention, which is Schedule 3, creates a very strong presumption in favor of enforcing foreign arbitral awards in South Africa.
So the default is enforce the award.
That's the starting point. Once a South African court recognizes a foreign award, it can be made an order of court, and then it's enforced just like any local court judgment. This gives international arbitration awards real power within the South African legal system.
Okay, what do you need to do to get it enforced? Just show up with the award.
Pretty much, though, with the right paperwork. The party wanting enforcement needs to supply the court with the original award and the original arbitration agreement, or properly certified copies. And if they're not in an official South African language, you need a sworn translation. Though the court does have some flexibility to accept other proof if those originals aren't available for some reason.
Right, so assuming you have the paperwork, when can a South African court refuse to recognize or enforce a foreign award? Are there loopholes?
The grounds for refusal are actually very specific and intentionally narrow. The Act lists them out, and they mirror Article 36 of the Model Law and Article V of the New York Convention again, that global standardization.
So what are they? Give me the main ones.
Okay, well, a court can refuse if enforcing the award would be contrary to the public policy of South Africa. But public policy isn't just anything the court dislikes. The Act clarifies it includes things like a serious breach of fairness by the tribunal that caused real injustice, or if the award was obtained through fraud or corruption.
So serious procedural issues or misconduct.
Exactly. Another ground is if the actual subject matter of the dispute simply isn't something that can be settled by arbitration under South African law, maybe certain criminal matters, for example.
Non-arbitrable. Got it.
Then there are procedural grounds, things like One party didn't have the legal capacity to agree to arbitration. The arbitration agreement itself was invalid. A party wasn't given proper notice of the arbitration or couldn't present their case fairly. The award deals with issues the parties never agreed to arbitrate. Or there were problems with how the tribunal was composed or the procedure followed, if that went against the parties' agreement.
Okay, so mostly about the fairness and validity of the process, not second-guessing the decision itself.
Precisely. And finally, enforcement can be refused if the award isn't actually binding yet in the country where it was made, or if it's already been set aside or suspended by a court there.
So these are pretty high hurdles to clear if you want to stop enforcement.
They are. They're designed to be exceptions, not the rule, reinforcing the finality of arbitration.
And what about trying to get an award actively set aside or canceled by a South African court?
Similar story. The model law in Article 34 says that applying to set aside an award is the only way to challenge it directly, and the grounds for setting aside. They are virtually identical to those narrow grounds for refusing enforcement we just talked about.
Okay, so very limited options for appeal, essentially.
Very limited. It underlines the whole point of arbitration efficiency and finality. Interestingly, even if a ground for setting aside is found, the court might actually pause the case and send it back to the arbitral tribunal to see if they can fix the problem, rather than just immediately canceling the award.
Trying to salvage it if possible.
Exactly. Preserve the arbitration outcome if it's fair to do so.
Okay, arbitration sounds very structured, very legalistic, which is good for certainty. But you mentioned conciliation earlier. Are there other, maybe softer paths promoted by this act for when parties want to resolve things perhaps less formally?
Yes, absolutely. The Act isn't solely focused on adversarial arbitration. Section 12 explicitly gives parties who have an arbitration agreement the right to try conciliation first. And remember, that includes mediation.
Before or even after starting arbitration?
Yes, before or after referring the dispute to arbitration. It highlights a clear legislative nudge towards trying to find amicable solutions first, if possible.
That's good. More options.
Definitely. And to help with that, Schedule 2 of the Act actually contains the UNCITRAL Conciliation Rules. Parties aren't forced to use them, but they can agree to, and it provides a ready-made, internationally recognized framework for how to conduct a conciliation process.
Okay, so how does conciliation under these rules differ from the arbitration process we've been discussing? What are the key distinctions?
They're quite different in their approach and goal. In conciliation, you have an impartial conciliator, or maybe a panel of them, whose job is to assist the parties in reaching their own amicable settlement.
Assist, not decide.
Exactly. Unlike an arbitrator, a conciliator doesn't impose a binding decision. They facilitate dialogue, explore options, maybe suggest solutions, but ultimately the parties themselves have to agree on the outcome.
Okay, more collaborative.
Very much so. And a huge feature is confidentiality. Everything related to the conciliation discussions, documents, even the final settlement agreement itself, unless needed for enforcement, must be kept confidential.
Why is that so important?
It encourages everyone to be open and frank. You can explore compromises or admit weaknesses without worrying it'll be used against you later if the conciliation fails and you end up in court or arbitration.
Ah, I see. Creates a safe space for negotiation.
Precisely. And parties typically agree not to start court or arbitration proceedings while the conciliation is happening to give it a proper chance to succeed. If they do reach an agreement, they draw it up and sign it.
And what about the conciliator? Can they switch hats later?
No, that's another key rule. The conciliator cannot act as an arbitrator, or as a lawyer, or even as a witness for either party in any later court or arbitration case about the same dispute.
Complete separation.
Complete separation. And any evidence, admissions, or proposals made during conciliation are generally inadmissible in those later proceedings, too. It's all designed to make conciliation a distinct, protected space for trying to find common ground, a really valuable alternative, or maybe a first step, before formal arbitration.
So wrapping this up, what we've really seen today is that South Africa's International Arbitration Act 15 of 2017 is, well, it's much more than just some dry legalese buried in a statute book.
Exactly right. It's a robust framework. It really puts South Africa firmly on the global map as a reliable place for efficient and fair international commercial dispute resolution. By adopting that UNCITRAL Model Law and fully embracing the New York Convention, it provides much-needed certainty. It champions party autonomy, letting businesses shape their own process, and crucially, it ensures that arbitral awards generally stick. They have enforceability. And, as we just discussed, it still leaves the door open for softer options, like conciliation.
Yeah, it seems to strike a really impressive balance.
Mm.
Respecting the parties' choices to arbitrate, keeping courts largely out of the substance, but still providing that essential judicial support and oversight when it's truly needed, like for enforcement or those narrow grounds for challenge. It must foster a lot of confidence.
It does. Confidence in the legal landscape for both South African businesses dealing internationally and for foreign companies looking to invest or trade here. It signals a commitment to being a reliable partner in global commerce. Which leads to a final thought, really, for you listening. How might this strong, harmonized approach to international arbitration continue to shape South Africa's role in global trade and investment? Could it encourage even more cross-border collaboration, knowing there's a solid framework for dealing with disputes, ultimately minimizing risks for businesses operating across the world? Something to ponder.